Members of the jury, good evening and welcome to the Supreme Court. Now, I am President of the Supreme Court and I am here this evening in order to preside over the proceedings which have been listed by Classics for All and to hold the ring. But the application before the court will be determined by you, the jury. You will, at the conclusion of the proceedings this evening, in about an hour's time, if counsel keep to their time estimates, be asked to decide the application before the court today. The hearing this evening involves taking us all back in time by just over 2,000 years, to the 4th day of October in the consulship of Gnaeus Pompey Magnus and Marcus Licinius Crassus. A young Julius Caesar has just been elected to the Senate, and the crowds are pressing for a sight of the action. People have been sleeping out overnight to ensure themselves a prime view. That doesn't often happen in this court. The action on this occasion is the renewed prosecution of Gaius Verres, the former governor of Sicily. In a curious and unknowably interstellar way, this Supreme Court, with me presiding and you as its jury, has been beamed from 2018 into the Forum of Rome on a hot October day in the year 70 BC to decide a preliminary application. The application must be determined this evening before the toll of human history can continue and the trial of Verres can take place, or not. The application is made on behalf of the defendant, Gaius Verres, by his counsel, in place of Rome's leading orator of the day, Quintus Hortensius Hortalus, Nicholas Purnell, QC, who leads, in place of Scipio Nasica, James Purnell of counsel. Could they by any way means be related, do you think? The application is resisted by the nominis delator, or special prosecutor, who holds the postulatus, or application to prosecute. That was, of course, Marcus Tullius Cicero, a younger up-and-coming orator keen to make his mark as a lawyer and politician. However, the director of the Serious Fraud Office has intervened and instructed Alexander Cameron, Queen's Counsel, who leads Leek Ponty of Counsel. The application is that the further prosecution of Gaius Verres on the allegations of crime, which include murder, robbery, and corruption, during the course of his governorship of Sicily, should be stayed as an abuse of the process of this court. The indictment contains 4 groups of charges: misuse of his judicial prerogatives, extortion through means of agricultural taxes, seizure of public and private works of art, and lastly, naval mismanagement. Gaius Verres has been brought back to the jurisdiction on a European arrest warrant from Marseille, which I believe is in Gaul, or maybe not, where he has resided since he suddenly left Rome. The heads of abuse, which this court understands are said to arise on the facts of this case, include, firstly, the degree of publicity surrounding his abbreviated first trial on the prosecution of Cicero. Secondly, the corrupting financial interest which the prosecutor had in that prosecution. Thirdly, the obtaining of evidence without relevant permissions. Fourthly, the paying of witnesses via expenses and accommodation. Fifthly, the fact that these allegations are made against someone who was in the position of an acting head of state. And sixthly, the fact that these allegations took place in a semi-autonomous province of Rome, namely Sicily. After the application has been made by counsel for Verres and responded to by counsel for the director, you will be asked by me, having considered the arguments on both sides and in the round, a simple question, which I will get you to answer by show of hands. The question will be, on the basis of all that you have heard, are you or are you not satisfied that it would be an abuse of the process of this court for Verres to face trial for the offences which are alleged against him? So I'll ask those who are so satisfied first to raise their hands, and those who are not so satisfied, secondly, to raise their hands. Mr. Purnell.
May it please you, my lady, members of the jury, as you see before you this somewhat wretched creature, Gaius Verres, a man who was accustomed to the pomp and ceremony of governor of a province, the province of Sicily, who left Rome in circumstances which you're all fully aware. His trial received the widest possible publicity that you could imagine. The moment the trial had come to its abbreviated conclusion, Cicero published 7 speeches. Only 2 of those speeches had ever been delivered in court, and they ranged widely over areas which were wholly inadmissible in any criminal trial. They covered his father, they covered a time span, they covered his appetite for women, and they were far removed from the indictment my lady has just described to you, which covers 4 principal groups of charges. And those speeches became available and were on the best-selling lists for weeks. Of course, they were available on tablet. And as a consequence, we are dealing with the problem which confronts courts day in and day out of how do you control the information which will be received by a jury were a jury to be sworn to try him in due course. And I'm going to come back to that problem because you may think it is a problem which exists and simply the courts have never been able to cope with it or develop a technique to deal with it in the current age. Moreover, it was abbreviated and abridged for the book at bedtime on Radio 4. And so, members of the jury, one has a situation where you come into court knowing so much about the case before my learned friend on behalf of the prosecution even begins to tell you of the allegations. And those allegations, of course, we only know through those speeches. There's no record of the evidence. The picture that's been painted of my client is one which has entirely been crafted by and designed by Cicero for his own purposes. I shall leave to my learned friend Mr. James Purnell the principal head of abuse, which is the self-interest and the motivation which Cicero had in becoming the special prosecutor. And of course, members of the jury, you appreciate that to describe my client as a man with appetites for women is as irrelevant as it might be to say whether Boris Johnson is fit for office, or Donald Trump is fit for office, or David Lloyd George was fit to be Prime Minister. That is far away from the issues which are to concern a jury were a jury to be sworn. And Gaius Verres is a man who was the governor of a province. He was pro-praetor. He had the power of Chief Justice. And so when my learned friend talks about murder, when my learned friend talks about corruption, when he talks about the seizure of works of art, you have to view that, if I may respectfully say so, in the context of a man who was responsible for a province, not someone who was lying in the comfort of Rome with the summer palaces on slopes and the silken girls bringing sherbet, but a man who was governor of an island which was at the heart of a state of emergency throughout the period of time. Spartacus lay offshore with his pirates. Onshore, there were rebels in the hills, mafia families waiting to raid and pillage at any moment. And that state of emergency was what my client had to cope with throughout the period of 3 years. Normally, the period of praetorship was only 1 year, but because of the state of emergency, he was required to do this public service over a period of 3 years. And so, members of the jury, one has got the problem. How does one confront the issue of the ability of a jury to pick up fake news on the internet, to have information fed into them which is way beyond the confines of the evidence in the trial? And as you may know, and if you don't know, I shall tell you, the time-worn formula which trial judges say to juries is that, members of the jury, you must close your mind to information which comes outside the courtroom. You must not access it. You must try this case on the basis of the evidence which you hear inside the courtroom from the jury box. Well, members of the jury, for a generation, many of whom find their life's partners on the internet, it's about as absurd as Brer Rabbit's exhortation to Mr. Wolf to not throw him into the briar bush. It is as if, as it were, a magnet is drawn for the jury to go out and find this information. And of course, it raises the issue of why it is that the director of the Serious Fraud Office has chosen this moment to execute the European arrest warrant and bring my client back to the jurisdiction. It was only in August that he came to the settlement with Cicero and the court, paid the $1.5 million sesterces, and pleaded no contest. Cicero would have it that he was fleeing the court, but every senior Roman citizen was entitled to plead no contest, and it's taken 2,000 years for the law of England and Wales to develop the deferred prosecution agreement. And so, is he to be punished? Is he to be tried again because he came to an agreement and a settlement which disposed of the criminal charges against him? And of course, the answer is twofold. The answer is that within 6 months, the director of the Serious Fraud Office will not have access to the European arrest warrant. and in 6 months, my learned friends and I will have no right of audience in the Rome court because we are subject to the dissolution of the freedom of access, freedom of movement. And so we will not be able to practice before you in this very important matter. And so all this has been concertinaed in a way which brings Gaius Verus to be tried now. And can I explain to you, because normally the question of an abuse of process application is reserved to the trial judge. But the public interest in this case and the significance of it, not only for my client, but more importantly for the administration of justice, is such that my lady has graciously consented that this issue should be tried by you. And can I explain the test to you? Because it was summarized very compactly by Lord Dyson, Justice of the Supreme Court, in a case called Maxwell in 2011. And he said this: it's well established that the court has the power to stay proceedings in 2 categories of case, namely 1, where it will be impossible to give the accused a fair trial, and 2, where it offends the court's sense of justice and propriety to be asked to try the accused in the particular circumstances of the case. In the first category of case, if the court concludes that an accused cannot receive a fair trial, it will stay the proceedings without more. No question of the balancing of competing interests arises. In the second category of case, the court is concerned to protect the integrity of the criminal justice system. Here, a stay will be granted where the court concludes that in all the circumstances, a trial will offend the court's sense of justice and propriety, or will undermine public confidence in the criminal justice system and bring it into disrepute. And those are the propositions that we, on behalf of Gaius Verus, submit you should take into account. You see, the difficulty about bias is its insidious effect percolates even when the subject or the person subjected to that bias is unaware of it. And I'm sorry to say that it percolates even to the highest level of the judiciary. It did cross the mind of Melanie Jr. and myself that we might need to ask the president to recuse herself. But
I thought you were going to say that.
But we've taken a different view because we are satisfied, as the court will be and as the jury will be, that My Lady's independence is such that it's irreproachable. But My Lady's colleague, Lord Roger of Earlsferry, sitting with others of My Lady's colleagues, Lord Brown and Lord Mance, had this to say in the case of Davis, which was decided in this court in 2000 and in front of the Judicial Committee of the House of Lords in 2010, Lord Roger's opening part of his opinion said this: "My lords, the intimidation of witnesses is an age-old and worldwide problem. When Cicero was intent on prosecuting Verres for his reign of terror in Sicily, highly placed henchmen of Verres threatened the fearful and oppressed Sicilian witnesses with dire consequences if they gave evidence against him. 2,000 years later, in Sicily, prosecutions of mafia bosses have been bedeviled by the prevailing atmosphere of intimidation, with its insidious counterpart, the Code of Silence Omerta. The same goes for prosecutions of Camorra clan members in Campania and drug traffickers in Colombia. Hollywood has made everyone familiar with the problem of witness intimidation in the United States, whether today or in former times. For many years, the wall of silence in London's East End frustrated attempts to prosecute the Cray twins until they were taken into custody in 1968 and people felt able to come forward to give evidence. In 1996, worries about the effects of witness intimidation led Strathclyde Police to introduce a witness protection program." Now, members of the jury, to couple my client, this man here, with the Cray twins is an appalling excess of judicial discretion, and in our respectful submission is a comment that never should have been made. And it never should have been made because there's no evidence at all, other than those speeches that Verres has made, that Cicero has made a great play with publicizing in his time-honored and tabloid journalist's way. There is no evidence that my client ever intimidated any witness, whatever. And so I want to come to the other problems. I have a very short time in which to do it, and I may not be able to cover them all in time. But the fact of the matter is that the evidence which is adduced against my client has been obtained entirely illegally, unlawfully. When Cicero went to Sicily in March of BC 70, he raided the revenue offices without any lawful authority and obtained the records, knowing that he was doing so without the authority of that court in that autonomous region. And knowing that he would not be able to remove the records from the island of Sicily, he spent nights with a team of investigators copying the material so that he could bring unofficial copies back and use as evidence against my client. He was forced to hand back the documents by the court hearing which took place in Syracuse the following day. But that, members of the jury, didn't prevent him from using that material in a way which is wholly unlawful. The court's control of entry and search warrants in this country is a very, very tight and strict control because it is an obvious infringement of your right, your human right to the quiet enjoyment of your home and your place of work. And the courts require the complete transparency of the application of the applicant as to why the court should be persuaded to grant that infringement. And Cicero simply ignored it, put the material together, came back to this country, to Rome, and set out to prove his case based upon those documents. Now, members of the jury, we have no fruit of the poison tree doctrine in England and Wales, unlike the United States of America. We have a situation where if material has been unlawfully obtained, it is inadmissible. It is struck out. You cannot use it. And yet this trial, if there is to be a trial, will take place against the background of that material. I come to other problems in the presentation of the case. And principally, that is that my client was head of state. Murder is the allegation, but these were not murders. They were the implementation of judicial sentences. It was judicial execution. And whilst that may feel repellent to a jury in 2018, let us not be so snooty, if I may use the phrase, about it, because when my lady and I came to the bar, we were practicing in a profession that was only 5 or 6 years after the suspension of the death penalty for murder. We were led by members of the bar who had defended capital cases and had to say to their client at the end of a guilty verdict that they would be taken from that place to be hanged. We appeared in front of judges for whom the black cap and donning the black cap was part of the judicial apparatus. And so for Gaius Verus, confronted by a terror situation, a state of high alert, then you have to, as it were, temper your repugnance about the sentences he imposed. And yet Cicero, on the one hand, was complaining that he murdered people, and on the other hand was blaming him for commuting life sentences to hanging sentences and imposing financial penalties. And so the fact that Verres was again 2,000 years ahead of his time is ignored by Cicero in the way in which he presented the case. And not only that, members of the jury, it was 1964 when Peter Evans and Gwyn Allen were hanged by the neck. And in 1971, in Northern Ireland, Liam Hayden was sentenced to death for the murder of a British soldier. Fortunately, the sentence was not carried out because in 2012, the Court of Appeal quashed the conviction by reason of the fact that his confession had been extorted by torture. And so let us not, as it were, assume a sense of righteousness about what Gaius Verus was confronted by. He's accused of enriching himself by taking works of art into his possession. He filled a warehouse in Messana. And again, if a jury is going to try him on that, the questions I ask first are, is the jury prepared to restore the Elgin marbles? Is the jury prepared to restore the Rosetta Stone to Egypt? Is the jury prepared to send back the Sultan Ganj Buddha to India or the Koh-i-Noor diamond? Because before Gaius Verus should be criticized for taking into his possession for transfer to Rome from the warehouse in Messana all those items, we have to look first at the mote in our own eye. In relation to his attempts to protect from the marauding savages and terrorists, we only have to look at Palmyra, at Mosul, and ask ourselves the question, given the state of emergency that confronted him, was he doing anything other than preserving natural heritage when he carried out his steps in that way? He's accused of having subservient judges. Well, members of the jury, is it unknown for a Supreme Court in a Western country to be elected by partisan votes and remain for life? Is that something which is so extraordinary, even 2,000 years later, that he is criticized for having judges that were politically, culturally, and avariciously aligned with his own feelings? And so, members of the jury, one is confronted by all these problems. He is accused of mismanaging the Navy. And that arises out of the attack which was made on Syracuse Harbor by Spartacus's pirates, when Cleomenes went out with a fleet of 7 ships and 6 of them were captured and destroyed. Was it wrong of Verres to put those captains on trial? Was it unfair of him to have Cleomenes, the admiral of the fleet, if I may describe him or elevate him in that way, as part of the tribunal? What better tribunal could there be? Because we, in our generation, until 1998, had capital punishment for dereliction of duty in active service, for damage to a naval shipyard. Death sentence, members of the jury, which retained in the civilization of the last decades of the 20th century. And so you're confronted by these issues of how it can be that this man can now receive a fair trial. He is brought before you, and the obligation is on me to satisfy you so that on the balance of probabilities, you can answer the question that will be posed to you by my lady. And we submit that when you look at the position that he adopts, when you look at the pitiful picture which he presents, he wipes his eye, I see, but it's hardly surprising. Drawn back here by use of this instrument deriving out of the European community, the European arrest warrant, he is in a very difficult position. And finally, the fourth charge that's laid against him is of extorting agricultural taxes from the farmers. Now, members of the jury, only in two parts of the Roman Empire, Sardinia and Sicily, was the basis of taxation a tithe, the decumi, which was controlled by the mafia. The position was that the highest bidder would obtain the contract to supply grain to Rome, and he would bid at a rate which gambled against how much of the crop would come in any year. Is it surprising in those circumstances that Gaius Verus would try and implement the common agricultural policy and create a situation that was level across the Roman Empire and not, in fact, one which was peculiar to the island of Sicily? And so, members of the jury, all these issues are going to be decided by a jury if there is to be a trial. But the particular concern is that how can he now have a fair trial? And if he cannot have a fair trial, then the interests of justice cry out for you to say that no man should be subjected to a trial which itself will bring the administration of justice into disrepute. This man, it doesn't matter how heinous the allegation, what is more important for all of us is that the criminal justice system remains a matter of integrity, a matter which we can be proud to demonstrate to the world. And if this man is to be tried now in these circumstances, then you and I and all of us fall down. Thank you, my lady.
Thank you, Mr. Purnell. Mr. Purnell, do you follow?
My lady, yes.
I'll take that. All right.
My lady, would that my learned leader could call upon her daughter to mirror her father's eloquence. For as all classical scholars know, the most skillful of the offspring of Quintus Hortensius was not his son, but his daughter, Hortensia, who in 42 BC, during the wars between the Second Triumvirate and the assassins of Julius Caesar, through her oratory and eloquence, persuaded the members of the Second Triumvirate to repeal the tax that they had imposed on the wealthy women of Rome for the purposes of funding their war, over which the women had no control, for they were unrepresented.
That sounds familiar.
And in so doing, she demonstrated more than 2,050 years ago something that your ladyship knows only too well: omnia femini equissimi. However, my learned leader has only sons. And so it is my privilege, three of whom are here tonight, but it is my privilege to represent, in junior capacity, Gaius Verus today. There are primary and political motives behind this prosecution, so unrelated to the proceedings that it renders this prosecution an abuse of process. I have 3 points to make. Accumulatively, they demonstrate that this prosecution is fatally tainted by reason of the prosecutor's manipulation of the process, and it must be stayed in order to protect the integrity of the criminal justice system. Although, in fact, each point I make would on its own be sufficient to stop this case. The first point is that this was a prosecution marred by the political interference and ambitions of none other than Pompey the Great. This prosecution was a political sideshow designed to legitimize his ultra vires consulship. My second point is that the same charge of political ambition can be leveled against Cicero. And my third and final point will be that between the two of them, Pompey the Great and Cicero manipulated the court's process secretly and oppressively. If I could take the members to 1986, to the Farquharson Guidelines, in which it was stated, the guidelines on prosecution counsel, it is axiomatic that prosecution counsel must exercise independent judgment throughout, with the objective not of obtaining a conviction at any cost, and with no personal interest in the outcome of the case. Fast forward then to May this year, to the Director of Public Prosecution's proposed Code for Crown Prosecutors, which says as follows: the independence of the prosecutor is central to the criminal justice system of a democratic society. Prosecutors are independent from persons or agencies that are not part of the prosecution decision-making process. Prosecutors must be free to carry out their professional duties without political interference, and must not be affected by improper or undue pressure or influence from any source. When making decisions, prosecutors must be fair and objective. Neither must they be motivated by political considerations. So turning then to my first point, Pompey's improper influence. What's Pompey got to do with this, you may ask? I will show you that he is the ultimate puppet master, lurking behind the whole of Gaius Verres' prosecution. It's no coincidence that the genesis of this prosecution was the complaint of Sthenius of Thermae, a wealthy man of illustrious birth with ties of clientship with none other than Pompey the Great. Cicero commenced this prosecution in 70 BC, during the consulships of Pompey and Crassus. Pompey and Crassus owed their consulships to what was effectively a coup d'etat. In 71 BC, they had been in command of armies engaged in the final stages of the suppression of the slave revolt led by Spartacus. But Pompey was too young to qualify for the office. He was only 35. He was below the age of eligibility to the consulship, and he had not held any public office, much less climbed the cursus honorum. Unlike Gaius Verres, the ambitious general had not been senator, he'd not been elected to the office of quaestor, or served as legatus, or promoted to proquaestor, or assumed the office of praetor, nor governor. And so in 70 BC, Pompey was looking to justify his unconstitutional seizure of power. And it is in that context that he lent his support to the prosecution of Verres. It was a tactical prosecution designed to enable Pompey to pose as the champion of clean government in the pretense of supporting allegedly oppressed provincials and to confront what he considered to be a senatorial monopoly of the law courts. You shall see when I come to my third point how Pompey improperly interfered with the process. But let me move to my second point, which is, what did Cicero have to gain by this prosecution? Well, off the back of this prosecution, we know that next year he assumes the office of aedile. And then what? We shall see him rise to praetor, and then in due course to consul. I ask you to recall, if you will, the words of Cicero himself when he laid the information for this charge, when he handed the postulatus to the praetor, Glabrio. "Citizens," he said, "today I come to offer my life in service to the Roman people. I wish to announce my intention to seek the office of aedile of Rome. I do this not out of any desire for personal glory, but because the state of our republic demands that honest men stand up for justice. You all know me. You know what I believe in. You know that I have long been keeping an eye on certain aristocratic gentlemen in the Senate. Well, I have in my hand a postulatus, and I am here to serve the notice of my intention to bring to justice Gaius Verres for the high crimes and misdemeanors committed during his term as governor of Sicily. If he is convicted, he will not only have to pay back what he has stolen, he will lose all civil rights as a citizen. Exile or death will be his only choices. He will fight like a cornered animal. It will be a long, hard battle, make no mistake, and on its outcome, I hereby wager everything. The office I seek, my hopes for the future, the reputation which I have risen early and toiled in the heat to gain, but I do so in the firm conviction that right will prevail." And there it is, ipsi dixit. This is a prosecution brought for personal and political gain. The prosecutor is personally conflicted. His interests are inextricably intertwined with the outcome of this case. And that brings me to my third and final point. The trial commenced on the 5th of August, 70 BC, only 10 days before the games of Pompey the Great. These would occupy 15 days and would be followed immediately by the Roman games. So what did Cicero do? In a break from procedural precedent, he announced that he would abandon the usual course of a long opening argument setting out the charges and the evidence he would call, but instead would embark on calling his witnesses at once. Let the so-called victims speak for themselves, without the addition of his own explanations of how the evidence would prove Verres' guilt. But how could he know that the praetor Glabrio would consent to such an unorthodox and novel procedure? He knew he, as the prosecutor, could not approach the praetor of the court himself. So he racked his brains and turned to the only man in Rome to whom Glabrio was honor bound to listen, Pompey the Great. And so Cicero went to Pompey and obtained from him the necessary pressure to exert on Glabrio in order to be assured that he could proceed as he wished and call his witnesses right away. And there we have it, the prosecutor, the praetor, and the consul complicit in collusion to subvert the process of the court to obtain a conviction at any cost. And so in conclusion, I ask you, in the words of Cicero himself, if this prosecution proceeds, cui bono? This is a politically motivated prosecution. It benefits Pompey. It benefits Cicero. This prosecution is an affront to the court's sense of justice and propriety. It is a misuse of the court's process, and it must be stayed accordingly. Unless I can assist your ladyship any further, those are my submissions.
Well, I'll reserve judgment on whether you've been of assistance. Okay. Mr. Cameron.
My lady, members of the jury, I'll do my best to move backwards and forwards through time as seamlessly as Team Purnell have managed. But I'm going to try and stay mostly with you, if you don't mind, in AD 70, which is where I think we all are. Anyway, if you didn't know before, Gaius Verres, the former governor of Sicily, is an operator. If you didn't know before, you certainly know now, because you may think, to misquote Oscar Wilde, to secure the services of one leading orator, Hortensius, who neither makes nor uses a note, is fortunate. To secure the services of another orator, Mr. Nicholas Pennell, who neither makes or uses a note, may be described as carefree. No such luxury is bathed in by the director of the Serious Fraud Office. And in this case, I would wager, in fact, that the defendant rather wishes he'd adopted the same practice of no notes, because during the course of his rape of the people of Sicily, because it was the meticulous records of his thievery which helped bring him to justice. And now, members of the jury, he has the brass neck to come before you, having fled the scene of his first trial in the face of the overwhelming evidence of crime, which even he felt unable to buy off, and ask you to stay the case against him as an abuse and allow him to walk off, as he did not very long ago, into the sunset towards southern Gaul, places we all know where people like to go and walk off into the sunset. And I'll come to deal with the heads of abuse that have been raised, on which Mr. Verres seeks to reply in order corruptly to get himself out of the corruption which got himself into this forum in the first place in a moment. But before I do that, I'd like to remind ourselves of the context of the application that's made today, because context is important, because abuse as a concept isn't a one-way track. It involves concepts of fairness and balance, and of course the interests of justice. And the context here is this. This is a man who, and in reality there's no dispute about this, as my learned friend Mr. James Pennell just made clear. Of course there was evidence called in the last trial. The situation wasn't that there was no evidence called and Cicero just made it all up. The evidence was called, and it was the result of the evidence being called that Verres disappeared off fairly sharpish. But this is a man who, on learning that Publius Gavius, a citizen of Rome, was on his way from Sicily to report him, Verres, for crime, he was arrested without trial, flogged, tortured with hot irons, and then crucified to death. A learned friend talks about a judicial process. His cross, I may tell you, was made to face the mainland in order to show him how close and yet how far he was from Rome. And this was all happening whilst at the port below him and in his sight, Verres was filling a ship with booty freshly stolen in order to bring it all here to Rome, artifacts, sculptures, and the like. To compare that with the Rosetta Stone and the Elgin marbles, you may think is stretching it a bit, not least because those artifacts ended up adorning the Caesoria, if you'll forgive the Latin, of the rich and powerful in the Senate. This is a man who had Nymphodorus of Centuripae hanged from an olive tree in Etna for complaining that all his livestock had been sequestrated, all of it just taken. Judicial process, we're told. This is a man who had Lucius Herennius, another citizen of Rome, beheaded without trial in the Forum of Syracuse for being a Spanish spy. This is a man who had stolen the renowned art collection of Sthenius of Thermae, and when he heard that Sthenius had come here to Cicero in Rome to complain about it, he had Sthenius convicted in his absence, for, yes, you guessed it, spying for Spain. And in his absence, he too was sentenced to be crucified. And then he had the cheek to send people to Rome, here Rome. They ransacked Aedile Cicero's house, purporting to look for Sthenius. This is a man who had an arrangement with the notorious pirate captain Heraclio. Heraclio himself, I may say, was never arrested, though his pirates were for a little bit, because the arrangement was thus. The arrangement allowed every ship that came anywhere near Sicily to be urged into the Sicilian ports, to be impounded by the governor for, yes, spying. Its contents were stolen, its sailors were imprisoned, and the books all falsely accounted for in order to pay no tax. While the contents were shipped back here to Rome, tax-free, as the property of Verres, to be lavished as a corrupt insurance policy, perhaps, on the great and the good. And then finally, this, just the worst, you may think, judicial process. It's matter for you to decide whether this is a judicial process. Those innocent sailors who had been arrested and imprisoned were executed by garroting, and their names were recorded as the names of Heraclio's pirates, who were released one by one. One innocent sailor garroted, one villainous pirate released. That is what we're dealing with, ultimately, in this trial, once we get over the heads of abusive process, which I'll come on to deal with now. And you'll appreciate that that's just the evidence that's available. You may think, and I quote the great Cicero directly here, because I, like he, am unwilling, by calling them to give evidence, to increase the distress of those men who have been unable to preserve their children and their wives, unpolluted by Verres' wanton lust. And so let's go to the heads of abuse, trying in doing so to put aside how Lucius Herennius lost his. Anyway, head 1, the obtaining of evidence without relevant permissions. This is otherwise known, as my friend Mr. Purnell fairly conceded, as the fruit of the poisoned tree. Well, of course, we don't have such a doctrine here. It's known, I think, really, anyone who doesn't have it, is the last resort of the guilty. And it all depends, doesn't it, on the fruit, not the tree. I mean, if the fruit is poisoned, then obviously you can't eat it. But if the fruit isn't poisoned, then you can. What is said here to be the poison? The obtaining of records without a warrant? Well, if the warrant had been issued, and as my friend seemed almost fairly to concede, given Verres' influence at every level in Sicily, there would have been no chance of getting a warrant. But even if a warrant had been applied for and got, the records would have disappeared by the time it was executed. And are the records, which are the fruit of the tree, are they themselves poisonous? No, they're the records. They bear witness to the real poison. Because we would suggest that there is a tree here that is poisoned. It might be described as a Verrian oak, and it cast a shadow over the whole province of Sicilia for about 3 years. So head number 1, members of the jury, I suggest you can deal with quite quickly. Head number 2, it goes something along the lines of Sicily being sort of something different from where we all are now. And my first argument in relation to that is that the idea that a province of Rome shouldn't come under the jurisdiction of Rome is a complete non-starter. After all, in this case, at least 2 people were murdered in cold blood while uttering the very words, "I am a citizen of Rome." They were saying that, of course, because they thought, rather like I'm sure all of you do, that a characteristic of being a citizen of Rome was that they had always, like you have, understood that that gave them the right to a fair hearing before they were judicially executed. And the irony of this defendant complaining that he can't have a fair hearing within months of the nails being hammered into the palms of an untried and unconvicted man who at the time was crying out, "I am a citizen of Rome," is to say the least a bit rich. And of course, richness is a concept with which the defendant is intimately familiar. But more generally than the province point, members of the jury, in whatever age one lives or has lived, there are certain levels of crime which overcome any notion of borders. I mean, after all, if the whole state is corrupt, to whom else can one turn? The scale of criminality alleged here plainly leaps the geographical boundary. And then mixed in with this point is a sort of head of state point. And I'm pleased it's been raised because it allows me to use a little bit more Latin, which of course we're not allowed to use in court anymore.
You're wrong about that, Mr. Cameron.
Well,
we welcome Latin in this building.
Well, my lady, this is my first appearance in this building.
Well, I hope you won't be dressed in that way.
I certainly won't be dressed in that way, madam, my lady, and I'll do my best to avoid it. But such an immunity, as my lady will know, is an immunity rationi materiae. And the nice thing about that is that two knockout points arise out of it from our point of view. First, that immunity is based upon sovereign equality, and Sicilia does not enjoy sovereign equality with Rome. And secondly, the acts about which we complain were not exercised as a head of state. They were acts of dishonest, private, personal enrichment in relation to the offence of dishonesty. Now, publicity. There have been, and will be the odd case where the trial process is brought close to jeopardy by pre-trial publicity. But the European Court, in a case called the X against Norway, recognised a long time ago the inevitability of publicity in a case which is of public interest. And there may come a day, of course, we in AD 70 haven't seen it, but there may come a day when information can be beamed around the world instantaneously, like a bird call heard everywhere, perhaps, but not here in Rome in the time of Pompey, or as a famous gladiator once said in the Circus Maximus, but not yet. But the jeopardy can be easily averted in any event. Firstly, if the decision is being made by more than one person, which it is here, you, the group tends to police itself, experience has shown. Secondly, the overseeing tribunal, in this case her ladyship, will be reminding the group of the obvious, that a trial is about what you, the jury, see and hear. It's not what someone else purports to have seen or heard that matters. Very easy not to worry about that. After all, you will have seen the witnesses yourself. That is what you will be told you're trying the case on. And frankly, the innate sense of right and wrong that is in all of us humans, whether in fact one's a wrongdoer or not, one still recognises wrongdoing. And then there's another, one of Mr. Pennell's own points, in fact, is that this trial never reached a reasoned conclusion. So, at least in this case, we haven't got the difficulty of a previously reasoned conclusion. All the more reason for you to decide the case on the evidence that you will hear once, with respect, this application has been summarily dispatched. And in this case, of course, there has in any event, been publicity both ways. Because as Mr. James Purnell has touched upon, much has been spoken of Marcus Tullius Cicero's vaunting ambition and of the interest he personally had and has in the success of this prosecution, all of which is publicity going the other way. We hear no application on his behalf. True it is, there have been rumours about Verres, and there have been publication of stories about Verres, but rumours are rumours, and stories are stories, and allegations are allegations. And Verres, of course, has received some strong support. I wonder why. From people in high places, people who might these days be described as influencers or opinion formers. And if, of course, those rumours come from his fleeing Rome himself, then it might be said, mightn't it, that he's only really brought the problem on himself. Ultimately, though, the question on this topic would be, has the pre-trial publicity been such that it's impossible for Verres to have a fair trial? Of course it isn't, we suggest, for all the reasons that I've gone through. The difficulty can be dealt with, because you're not going to try the case on tittle-tattle and what's happened in the past. The witnesses will be brought before you, those that are still alive, to come and give evidence, and you will be able to judge them. There was going to be a little allegation, I think, about the paying of witnesses, but that hasn't been developed, so I won't bother to deal with it. But the short point about that would be this: it's not a question of paying for witnesses. I mean, Sicily's quite a long way away. One can't get here overnight. And this isn't even a warned list case. It's a floater with no fixed date. And as we all know, court time can't be wasted. We're often told that. Witnesses must be ready to come to court, and a witness can't survive on thin air. And these are witnesses, of course, who all of their worldly goods have been stripped from them by the defendant. So frankly, someone's got to feed them and water them and house them in order for them to be able to come and tell the truth to you. Of course, if a witness is being paid to give false evidence, the position's slightly different, but you may think that's something that's rather unlikely to come from this side of the court, although I can't deal with what might come from over there. Mr. Ponti, my junior, who, as his name suggests, has come here by, with, or from a bridge, probably Westminster Bridge in this case. But he's going to deal with what's said to be Mr. Cicero's personal conflict of interest. But the issue more generally of whether a prosecution should be brought by anyone other than the state is an important one. And the answer must be, must it not, and this is the answer that was found by Lord Byng of Cornhill when he was presiding over the predecessor of this court, and was recently upheld by the last Lord Chief Justice, Lord Thomas of Cumgeath. This was held to be the position. The answer must be, must it not, that if the same rules are applied by a private prosecutor as by a state prosecutor, that there isn't a problem. An issue arises, it's absolutely right, as to how the abiding by the rules can be monitored. We would contend that in an adversarial system, it will quite naturally be monitored by the adversary. Requests for disclosure can be made, the disclosure can be policed by the tribunal, and if it goes wrong, the wrong can be revisited and righted. But in a free country, if the criminal law of the land has been broken, and for whatever reason the state has decided not to prosecute, it's only right that an individual can seek to enforce the law of the land. That enforcement will, of course, be monitored. The state has a right to take over a prosecution and either prosecute it or stop it. And that decision can be the subject of review. So there isn't any difficulty, as a matter of basic principle, with Cicero prosecuting the case. Well, where does that leave us, members of the jury? It leaves us with Mr. by, with, or from a bridge dealing with the submissions of Mr. James Purnell about the personal aspect of this, and it leaves me to leave you with this thought. And in the same way that there was an element of challenge to the Senate in the way that Cicero conducted the trial last time, which was effectively, if you acquit this man, it will prove that you, as well as he, is corrupt. There's an element of challenge to you by me. because the real effect of all of the submissions that you've heard from the other side of the court is really an attack on the system of justice itself, an attack on you. The effect of those submissions is to say that you, the jury, will not be able to act honestly, responsibly, discriminatingly, fairly, and incorruptly when considering or reconsidering the evidence. And that, in the circumstances we submit, is an untenable proposition. Moreover, members of the jury, what state will the criminal justice system of Rome be in if it is possible willfully to abscond from your trial because the evidence against you is so overwhelming, and having been apprehended, skulking in Marseille, eating, no doubt, a lot of bouillabaisse, and brought back by an interstate warrant, a European arrest warrant, not voluntarily. You had to be arrested, found, arrested, and brought back. And then effectively you asked to be acquitted because of the circumstances that you yourself have brought about by absconding in the first place. In our respectful submission, you only need to spell it out like that to know the answer. And so in our respectful submission, we will be asking you to answer the question very firmly, that of course it's possible for Verres to have a fair trial, and of course it is not right that it should be stayed as an abuse.
Well, Mr. Bywithall from a bridge, do you follow?
I do, madam. My lady, members of the jury, you have had the benefit of submissions from 3 very learned counsel, and I fear that I, as a lowly junior public prosecutor, may be able to add little to these proceedings. My learned friends wear their erudition lightly. They have no doubt read their Pliny and their Livy and their Tacitus, where I have merely managed to skim the works of Wikipedias. The Purnells, no doubt, have read Cicero's speeches in the original Latin. The closest I have come to reading a key text in its original form was the hardback of Imperium by Mr. Robert Harris. I do note in passing, my lady, that from my meagre historical researches, the advocates in the forum were invariably male and of a certain age, and largely drawn from a narrow patrician class.
Sounds familiar.
Yes, I was going to say, can I congratulate Classics for All for such historically accurate casting of tonight's proceedings? But I digress. The defense apply to stay these proceedings as an abuse of this court's process. They say that there should not be a trial of Governor Verres, the most depraved, the most wanton, corrupt, and degenerate man in the Republic. Allegedly, a number of points are made on his behalf, and they're made impressively and persuasively and eloquently. Procedural points are taken, and jurisdictional points are taken, and academic points are taken. And I, as a lowly junior public prosecutor, do not profess to understand all the points that have been made. But I answer them with the submissions that are made in every court in the land where prosecutors face an application to stay proceedings as an abusive process. I submit to you, members of the jury, that the trial process, the modern trial process, is flexible and it's dynamic and it's well equipped to deal with all the complaints that are raised on behalf of Governor Verres. So some of the evidence has been obtained by somewhat unconventional means. There can be an application to exclude that evidence in the course of the trial. So the prosecution is attempting to shoehorn months of evidence into a 10-day trial. We can sit longer hours, my lady. It is said of the prosecution that they were originally motivated entirely by greed and self-advancement and self-promotion. Well, nobody's perfect. I'm sure that could be cured by careful direction to the jury to ignore those matters. The one substantive matter that I do seek to reassure the court and the jury is the issue of disclosure in this trial. The court and the jury will no doubt be aware that there have been difficulties with disclosure in the Roman court of late. Disclosure is frequently misunderstood by investigators, as Mr. Purnell noted, due to the recent proliferation of tablets. There's a great deal more material than was originally envisaged by the legislation. Disclosure can sometimes be under-resourced. These are difficult issues, and no doubt they can be solved at some time within the next 2,000 years. But I should reassure you, members of the jury, that Mr. Cameron and I have personally reviewed the unused material. It's all been dealt with entirely in accordance with the Counsel General's guidelines on disclosure of unused material. And it made for the most magnificent bonfire. There is something particularly warming, my lady, about the flames of exculpatory material.
I'm beginning to wonder which side you're on.
My 5 minutes are nearly up, and I wish that I had a strong peroration with which to end these submissions, but I don't. So I end simply with a personal note, and I hope the court will permit it. I know that it may not be truly material to the court's considerations, and I know that an advocate ought not to give evidence in the course of his submissions, but this case has been in my diary for 2,000 years now. And I'm extremely anxious that if it goes off, I'll be in the Crown Court at Pompey tomorrow morning. And so I ask you, for my sake, if not for the sake of the Republic, please, can we swear a jury and call the evidence and go ahead? Those are my submissions, my lady.
Thank you, Mr. Bronte. Yes. Well, members of the jury, you obviously have been given a great deal of food for thought. So in order to enable you to consider your verdict very carefully, there will now be a short intermission where you will have the benefit of an exposition of classics for all and the lawyers group. Well, members of the jury, when you come to consider your decision, you will have to ignore everything that you have just heard, because otherwise undue sympathy for the defendant might cloud your judgment. When considering whether your sense of justice would be offended, you might want to bear in mind the principle established by the great Lord Bingham up there in the case of Bentley, from the famous case of Craig and Bentley, that the trial is to be judged by the standards of today rather than the standards of yesteryear. But those standards, as we have been reminded, are modern, flexible, and dynamic. You may also want to bear in mind that in the light of certain modern parallels with the behaviour of Verres, to which our attention has been drawn, that juries ought to impose upon defendants the standards the law imposes on defendants and not their own standards. So please bear both of those things in mind when you answer my questions. On the basis of all that you have heard, I will ask you first, those of you who are satisfied that it would be an abusive process for Verres to face trial for the offences which are alleged of him, kindly raise your hands. Those of you who are not so satisfied, kindly raise your hands. Well, despite the eloquence of Purnell, Pater and Filius, the trial will go ahead. Thank you, everybody.